All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience à la Cour pénale internationale est ouverte. Veuillez vous asseoir.
Good morning, everyone. Could the court officer please call the case?
Good morning, Mr. President, Your Honors. Situation in the Central African Republic. The case of the prosecutor versus Jean-Pierre Bemba Gumbo et al. Case reference ICC 0105-0113. And for the record, we're in open session.
Thank you very much. I ask, like always, for the appearances of the parties. We start with the prosecution. Mr. van der Poeje.
Good morning, Mr. President, Your Honors. Good morning, everyone. Today, the prosecution is represented by Ms. Olivia Straven, seated to my left. To her left, Nima Milaninia. Behind him in the middle is Priya Narayan, and next to her is Michelle Rege. And in the back row is Sylvie Wakchom on the right side. In the middle, Carmen Garcia Ramos, and to her right, Yassine Mosba. I'm Kweku Van der Poel. Good morning.
Good morning. Thank you very much. And for the defense teams, I think we start with the defense for Mr. Bemba.
Good morning, Mr. President, Your Honors. My name is Melinda Taylor, and I'm appearing on behalf of Mr. Bemba today with Ms. Ines Pierre de la Briere. Thank you.
Thank you. Mr. Carnevas, please.
Good morning, Mr. President. Good morning, Your Honors, and good morning to everyone in and around the courtroom. I'm here for Mr. Kololo. I'm along with Rosalie Beng and Anastasia Tatarenko. Yeah. I got through the names this time.
Thank you. And Mr. Gosnell for Mr. Mangenda.
Good morning, Mr. President, Your Honors. Christopher Gosnell for Mr. Mangenda this morning, assisted by Peter Robinson and Nikki Sethi. Thank you.
Thank you very much. And before we start with the intervention, so to speak, and the oral submissions by the parties, I have to say a few words on behalf of the Chamber. Just for the record, the three convicted persons are all out on interim release and have not been ordered to attend today's hearing. By way of background, on 19th October 2016, Mr. Bemba, Mr. Kilolo, and Mr. Mangenda were found guilty of offenses against the administration of justice related to intentionally corruptly influencing witnesses and soliciting false testimonies of defense witnesses in the other case against Mr. Bemba at the ICC. On 22nd March 2017, this chamber delivered the sentences in this case. On March 8, 2018, the appeals chamber confirmed the convictions in respect of most of the charges. The convictions and acquittals in relation to these three convicted persons are now final. However, in relation to their sentences, the appeals chamber reversed them following a successful prosecution appeal and remanded the matter back for this chamber to make a new determination, and this is why we are sitting here today. The chamber recalls at the outset that it has set a clear briefing schedule in this case. Written submissions were sought pursuant to Order 2277 and have now been received from the parties. These submissions can be found across filings 2279 till 2282 in the case record. On 12th June 2018, the Chamber announced that it would have this hearing to discuss the resentencing. This hearing also resolved multiple requests from the parties to make further submissions, including a prosecution request for leave to reply in filing 2283. And now we come to the current developments. No further written submissions have been permitted in this case. Today's hearing marks the conclusion of the submissions the Chamber will receive prior to its resentencing decision, with an exception I will come shortly to. Because yesterday the prosecution filed a written submission outside the parameters of the Chamber's briefing schedule. This is filing 2296 in the case record. The prosecution has not sought leave before doing so. However, it concerns the impact of the main case appeals judgment on the resentencing. it is of course understood that the main case appeals chamber judgment postdates the prosecution's original written submissions. The prosecution may therefore use its time today to raise the same arguments should it wish to do so, and the defense teams may use their time to orally respond to them. However, the chamber is also aware of the fact that we have now a written submission in the case record, and that the defense is in the position to feel perhaps a little bit ambushed by this last-minute submission. So we understand that, and because of that, the defense teams will be granted the possibility to respond to this filing by the OTP, and only to this filing and what is raised in this filing within 2 weeks by written submissions. No further submissions on any issue in this case will be permitted by the chamber. This is out of fairness to the defense that we allow this. But we would appreciate it a lot if defense counsel would be able to respond today, now that we are sitting here in this hearing, orally to the filing by the prosecution. There might be some basic considerations that an experienced defense counsel might be able to talk about orally now, but you are permitted to respond to that. The chamber received word that Mrs. Taylor wanted to address us and make an oral application, and I hope a little bit that with my wordings that further discussions on this point might be moot. You have the floor, Mrs.
Thank
Taylor.
you very much, Mr. President.
I only want I have not finished. I have not finished.
Okay.
I have not finished it. I only wanted to express my hope that further applications by you are moved by that. You can simply give me a sign, so to speak, or simply say yes or no.
Thank you, Mr. President. I'm afraid that doesn't address the core thrust of our oral application that we intended to make. Thank you very much.
Then we wait until I have finished my intervention, and then you can have the floor. The purpose of today's hearing is to hear any final supplemental arguments from the parties, particularly those arising from submissions or events subsequent to their written submissions. There is no need for the parties to repeat their duly received written submissions, of which the chamber is well aware. You can trust that the chamber has read your written submissions, and we don't have a oral hearing here to simply repeat the arguments. The chamber therefore expects today's submissions to be short and sharp. We expect to finish comfortably within a single day, at least at this moment. We still expect it. After the hearing, the chamber will resume its deliberations on the appropriate sentences to impose. These new sentences will not be pronounced today, as you will expect, but will come in due course. The chamber will first hear from the prosecution, then from the defense teams in the order they deem fit. But since you have an application, I give firstly the floor to Mrs. Taylor.
Thank you very much, Mr. President. Of course, we appreciate that the chamber has afforded the defense with a remedy in relation to yesterday's submissions, but in our respectful view, and for the reasons that I will elaborate, that remedy would not cure the harm of the submission itself and of the possibility for the contents of that submission to be ventilated today. We respectfully request, through this application, for the submission to be dismissed in limine and for the prosecution to be directed to refrain from repeating the contents of that submission at today's hearing. And there are two reasons for this request. Firstly, the submission is based on an inadmissible premise. They are based on the premise that Mr. Bemba's acquittal in the main case harmed the integrity of the court. And in our respectful view, it would constitute an abusive process to invite this chamber to re-adjudicate final findings of the main case appeals chamber and to question Mr. Bemba's acquittal in that case. The second plank of our submission is that they are completely irrelevant to the issues before this chamber. They fall outside the scope of this case and the scope of this hearing. Finally, we submit that the only purpose to which the chamber can turn to this submission is to mitigate Mr. Bemba's sentence in light of the harm that has been generated through the public submission of these views. In terms of our first argument, the prosecution submissions are predicated entirely on their subjective view of the truth. They claim that a particular narrative is false and that because the appeals chamber accepted certain elements of this narrative that might not be false, the findings of the appeals chamber, the majority, were corrupted. In our respectful view, this premise cannot be entertained in any shape or form. The trial chamber has neither the means nor the statutory authority to revisit factual findings issued by a final verdict of the appeals chamber, or to cast its own inflection on the evidential record. The prosecution had a full and fair opportunity to make submissions concerning the reliability of defense witnesses in the main case. It's never claimed it didn't have that opportunity. Now, the fact that it disagrees with the outcome of that litigation is neither here nor there. The outcome exists, and it's final. But in yesterday's submissions, the prosecutor has appointed itself judge, jury, and executioner of the main case acquittal. And that's not how this court works. It's not how justice works. Judges at this court have a duty to act honorably, faithfully, impartially, conscientiously. And as noted by the ICC president in his public statement, when judges acquit or convict, it is because the core principles direct them to do so. Mr. Bemba was acquitted not because of Article 70 conduct, but because his core values directed the majority to enter an acquittal. Now, it is entirely inappropriate to play to the peanut gallery by using this hearing as a forum for expressing the prosecution's continued disagreement with the majority of the appeals chamber and its disagreement with Mr. Bemba's acquittal. To do so would undermine the authority of the court, and it undermines the public perception of Mr. Bemba's innocence in that case. In our respectful view, it simply should not be allowed. And it would be quite wholly inappropriate for the prosecution, which is tasked under Article 54 with upholding the rights of the defendant, to claim that an acquittal constitutes damage to the integrity of this court. Now, in terms of the second plank of our submission, these submissions, yesterday's submissions, are additional arguments. They're not a reply to the arguments of the defense. They constitute an entirely new approach, a new hypothesis on a range of issues that are unconnected to the specific points before this chamber. Now, as the presiding judge mentioned, these issues are the extent of damage, the impact of solicitation versus co-perpetration, and the chamber's error in granting suspended sentences. And the prosecution has filed submissions on these issues and asked to file a reply on these issues. And none of those filings raised the matters set out in yesterday's filing. And they never asked to expand the scope of their submissions, because if they had done so, they would have no basis to tie yesterday's submissions to the scope of this case. Yesterday's submissions brings entirely new substantive arguments as to whether defense witnesses lied on the merits of the main case. These are matter that the Chamber has found fall outside the scope of this trial. It falls outside the scope of Article 71(8). And the prosecution was found on appeal to have acquiesced to this limitation. That is, that it was limited to false testimony concerning contacts and payments. Now, this acquiescence should bind the scope of this hearing, as does the prosecution's choices concerning charges and allegations. This case concerned 14 witnesses. Now, if they had evidential grounds to believe that other witnesses, such as D48, were corrupted, then they could have included them in the Article 70 charges. But they didn't, which speaks volumes concerning the reliability of yesterday's submissions. Now, this is not a point on which the prosecution can hedge its bets. It can't wait to the penalty shootout and then try and change the team and try and change the rules. That's not how a trial works. We don't need just 2 weeks' notice. For allegations of this sort, we would need a new trial, because this is an entirely new charge. Time's up for the prosecution. It's simply too late to reopen the case in this manner. And my final point concerns the impact of hearing such submissions on the presumption of innocence of Mr. Bemba. The presumption of innocence is not just a phrase or empty words that fill out the statute. It's a fundamental right. And it's a right that's at its highest after a person has been acquitted on final appeal. And as found by the European Court of Human Rights in Geerings versus Netherlands, following such a final acquittal, even voicing suspicions concerning the accused's innocence is no longer admissible. Now, the prosecution in its submissions, they haven't just voiced suspicions, they've out and out said that the acquittal was secured through corrupt conduct. They've also said that he was only acquitted of some of the charges, clear inference being that he was guilty of others. That can't be accepted. That's inadmissible. That basically tries to crush the life out of his acquittal. That's harmful. It's prejudicial both to his individual right to innocence, but also as concerns the fairness and impartiality of this process. And it's not the first such statement, obviously. Similar statements were made during the release hearing. The prosecutor also made a very public statement, and when we invited her to retract it, declined to do so. We therefore ask this chamber, in addition to dismissing these submissions in limine, to take into consideration the harm that these public statements have caused to Mr. Bemba's rights, and to do so in its assessment of the appropriate sentence to be imposed on this case. And this would be consistent with the approach of Trial Chamber 1 in Labunga, which took into account the statements of the prosecution spokesperson when sentencing him. Thank you.
Yeah, Mr. Canovas, shortly, please.
Very, very shortly, Mr. President. Thank you. And I appreciate the trial chamber's ruling on this. However, these submissions are both deceptive and deceiving. It's not a notice. It's a full-blown submission. And the prosecution, I don't know whether it's this gentleman or whether it's Madam Bensouda, are engaging in what I would consider guerrilla war tactics. At the last moment, they file what is called a notice when it's a submission. The notice could have been 2 paragraphs, the first one and the last one of this 20-page submission. Why they did this, I think my colleague explained the reasons. But I think that I would concur that it should be outright dismissed, and they should not be rewarded with the opportunity to speak on this matter, on these matters that they want to raise. If we are to file submissions, we should have 4 to 6 weeks. And I think because, in my opinion, these sort of tactics, no matter which side engages in them, when they don't file a leave or they file a bogus notice, this is borderline unethical behavior, and it warrants a sanction. Now, the sanction could be, for instance, if we're going to spend a month working on this, the prosecution ought to pay from its budget the defense. It should be, because this is the only way they're going to learn to refrain from these sorts of tactics. Thank you.
Mr. van der Poeyer, I assume that you perhaps want to make some remarks on this.
Thank you, Mr. President. Yes, if you'd like me to. I have to say, I almost can't believe my ears. And the reason why I almost can't believe my ears is that you're listening to the words of counsel who represent clients who have been convicted by this trial chamber on proof beyond a reasonable doubt that their clients sought to subvert the course of justice in this institution. I'm listening to Mr. Carnavas talk about the prosecution's ethics concerning filing a notice of the arguments it intends to make orally before this chamber in advance of the hearing as an unethical act as compared to the client that he represents who was convicted by this chamber and by the appeals chamber in affirming those convictions of 28 counts of crimes or offenses against the administration of justice. I'm listening to Ms. Taylor, who represents Mr. Bemba, who was recently acquitted in the main case, but who was also convicted in this case on evidence and proof beyond a reasonable doubt of his misconduct, criminal acts designed to subvert the course of justice before this court. So I'm really almost at a loss for words. Because at the end of the day, what we assert, and they can respond to, and you've invited them to do so, is that those efforts played a role in to a discernible extent in the result. The result of the acquittal was the aim of the common plan which this chamber found. And so that is the basis for our application. We filed it as a notice to give the defense an opportunity to respond. They can take it however they want. But we do intend to make those arguments and elucidate them for the chamber's benefit, with the chamber's leave, of course.
Thank you. So the ruling of the chamber is the following. I address first Ms. Taylor. You have already effectively answered to the submission, so to speak, and have another possibility to do so together with the other defense teams in written form, and therefore no prejudice to the fairness of the proceedings warrants the prohibition of the acceptance of the prosecution's submission. The prosecution has wide latitude in what kinds of arguments it wishes to raise before the chamber. The chamber will not declare them inadmissible from the outset in the manner the Bemba defense suggests. The request is rejected, but the Bemba's defense concerns about the prosecution's arguments are, of course, noted as any argument that is brought forward, and will be, of course, like any argument that is brought forward, considered when deciding upon the merits of the prosecution's arguments. That said, I invite Mr. van der Poeyer to make his oral submissions. And I would really now wish from everyone in the courtroom, from every party, to concentrate on the issue at stake, meaning the arguments that might be brought forward, pro and contra a certain sentence for the three accused that are represented by counsel in this courtroom. And the chamber would very much appreciate it if we would now refrain from reciprocive, so to speak, reproaches. So please concentrate on reasonable arguments. This is why we are sitting in a courtroom. We are not acting for the gallery. This is addressed to everyone here. Mr. van der Poel, and please, as I said, short and sharp. We have written all the submissions.
Thank you, Mr.
Of course,
President.
not written. We have
heard them.
read all of those.
Yes.
Of course, not written.
If you could just bear with me one moment while I move the podium over here and set up. It'll take me just a second.
Mr. van der Poel, we have also to address now the shortly before you start the submission by Mr. Carnovas that you wanted more time, as I understood it, 4 to 6 weeks, as I understood it, and we reject that. Frankly speaking, we have already considered 2 weeks to be appropriate under the circumstances. The Chamber sees no reason why it takes a month or longer to respond to this filing. 2296, and the defense have already been given longer than the standard 10-day response time limit specified in Regulation 34, the regulation of the court. And I'm absolutely sure that two weeks will be enough for you to address the arguments that you want to bring forward to this chamber. And as I also have already said, Mrs. Taylor has brought forward some already.
I apologize, Mr. President. I have a very discrete point which ties to the prosecution submissions because they are based on a lot of factual issues which simply aren't in the record in this case. We don't have disclosure of a lot of these issues. So at this point in time, it's entirely uncertain as to whether the prosecution will disclose and what they will disclose, particularly in the absence of any direction from the chamber. As I mentioned, it does refer to a witness who wasn't even in this case. So it does raise a point for us in terms of how we are to respond when we haven't had disclosure of the underlying main case materials. Thank you.
Mr. van der Poel?
I'm
To,
not
the,
su-
to this point.
yes, Mr. President. I'm not sure exactly what documents Ms. Taylor is referring to, but if she's referring to the CDR that is referenced in the notice, I would say that information was in fact disclosed in this case. Not only was it disclosed, but it's in the record of the case as formally submitted. And I can provide the references for that if she would like it.
If we are talking about especially this part of the record, I think it would make sense simply to clarify what's the state of affairs. We cannot do this now at the moment, and you can do this inter partes, in my opinion. And if of course, the defense is not able to meaningfully respond, then we would have to reconsider perhaps the time frame we have set out.
Mr. President, I have the references right here in front of me. If it's that, I don't know what specific information she's talking about. But if it is that, I can provide it.
So what we do then is perhaps we have still a hearing until perhaps in the afternoon, the late afternoon, if you will, and we can we would appreciate it. I would appreciate it if we could resolve this until then. What you need, Ms. Taylor, and what you can provide, and of course to keep this relatively tight time frame, we would appreciate it if you would be forthcoming. Mr. van der Poel.
Thank you, Mr. President. I'll do my best to move things along. I wasn't aware of what the time constraints might be with respect to the presentation, and I have... I'm sorry, is it? Okay. Perhaps I was just standing a little bit... I wasn't aware of what the time frames might be allotted to the parties to make their argument, so I did prepare written a written submission that I will obviously present orally. So I'll do my best to try to get through it, but I think it's probably a little bit on the long side. I'll cut it as I go, but I'm not sure exactly how long it is at this moment. I think it's about an hour.
About an hour is okay, but not more, please.
I'll do-
Then
I'll do my best.
yeah, and then please begin.
Thank you. All right, well, good morning, Mr. President, Your Honors, everyone, and it's my privilege to appear before you once again concerning this case on behalf of the Office of the Prosecutor and my team. I understand that we have a limited amount of time, as you have stressed, so I'll do my best to try to move things along and get to the point. Our submissions cover a few salient issues that we believe will assist the Chamber's new determination And we also believe that they're imperative to the determination of the appropriate sentences to be imposed here. And the sentences that we would ask for should reflect the true gravity of the numerous crimes that were committed, the seriousness of the criminal course of conduct that was engaged in by the defendants, the consequences of their actions, and the risk of and the actual harm done to the proceedings, the court, and to the public confidence that's necessary to its ability to fulfill its mandate. So we will address, in turn, the impact of the main case appeals chamber's acquittal of Mr. Bemba on the sentencing determination to be made by this chamber. We will address the impact of the chamber having in its determination on sentence accorded some mitigating weight in view of its findings on the basis of the evidence that it restricted itself to considering for practical reasons, that the false testimony of the witnesses did not go to the merits of the main case. We will address the impact of the chamber's having in its determination on sentence considered accessorial modes of liability per se is less culpable than those arising, adhering to the acts of a principal, and the impact of the appeals chamber's dismissal of the convictions entered under Article 71B. We will address the defense's proposed sentencing alternatives, and we will also address briefly the alleged circumstances, individual circumstances of the defendants. Before I turn to these specific points, I would like to note a couple of things. The first is that while the appeal chamber remanded this case for new sentencing determinations, it also overwhelmingly confirmed your determination beyond a reasonable doubt that the defendants in this case indeed committed multiple violations of Article 70. In short, the appeals chamber unanimously affirmed the convictions, even having dismissed the charges, or the convictions rather, under 71B. In respect of Mr. Bemba, 28 counts. In respect of Mr. Kilolo, 28 counts. And in respect of Mr. Mangenda, 23 counts. No matter how you view this, the sentence to be imposed, given the gravity of the case and the course and scope of the defendant's criminal conduct in the context of implementing a broad and pervasive scheme to pervert the course of justice and undermine the integrity of the proceedings before this court, cannot be less than the maximum allowable for any given offense. That's 5 years and a meaningful fine. Anything other than that in these circumstances, in our view, is patently untenable. And rather than stem impunity, it would promote it. Your Honors, it just doesn't get any worse than it is in this case. A campaign to corrupt witnesses before a court in a serious case, a very serious case. And this unreservedly demands the imposition of the highest sentence available under the statute for each of the convicted persons. It demands this high sentence because it is the only sentence that accounts for the gravity of the conduct involved, its consequences, the damage it caused not only to the trial of the main case, but to its outcome, which I will come to momentarily, as well as the integrity of the proceedings and the processes before this institution. It is the only one that accounts for the undermining of public trust that this court depends on and needs in order to discharge its crucial mandate. And there's one more thing, which I think answers a question of my colleague. At the initial sentencing hearing in December of 2016, a year and a half ago, we said, the crimes of which the chamber has convicted Bemba, Kilolo, Mangenda, Babala, and Arido on 19 October 2016 put at risk the court's mandate. Simply put, to do justice. Justice in respect of the crimes of the most serious concern to the international community, Justice in respect of the victims of those crimes, more than 5,000 of them, before this court of last resort. Justice in respect of ensuring the fairness of the proceedings enshrined in the statutory framework concerning the parties and participants before this court. And of course, justice to the court itself to protect its integrity, its credibility, its standing, and its authority so that it can actually fulfill its mandate now and in the long term. That's what we said in December of 2016. We also said this: while one might suggest that the most immediate harm to the court was averted in Bemba's main case trial because the ultimate goal of the common plan to unlawfully obtain his acquittal did not materialize, recall this: the main case is not final, and beyond the main case, only time will tell what long-term damage to the court there may be. That's what we said a year and a half ago, long before the appeals judgment was issued. And yet here we are. Those risks have come to fruition. The appeals chamber's remand of this matter for a new sentencing determination is a reprieve for this court. Importantly, it is an opportunity for this chamber to set things right once and for all. As we all know, a different composition of the appeals chamber recently acquitted Mr. Bemba of his convictions for crimes against humanity and war crimes entered by Trial Chamber 3 in March of 2016. And while there were a number of reasons for this, including what appears to have been the application of an unprecedented standard of appellate review regarding the factual determinations of a trial chamber before this court or any other international court or ad hoc tribunal, the defendant's implementation of the common criminal plan to illicitly interfere with defense witnesses in the main case in order to ensure that the witnesses would provide evidence in favor of Mr. Bemba. This is the chamber's finding of the common plan at paragraph 103 of the trial judgment. Those actions contributed at least in discernible part to the appeals chamber's analysis of the relevant facts and its decision to acquit. In short, the plan that was set in motion at trial before Trial Chamber 3 ultimately succeeded just a couple of weeks ago. In the words of Mr. Kilolo, in a recent interview that he gave to the Congo Independent on 11 June 2018, that's on the internet, he was asked a question by the interviewer. The first question is simple. How did you feel when you heard Judge Christine van der Weingart of the Appeals Chamber pronounce the word acquittal? What feeling did you experience? His response: un sentiment d'un devoir accompli. Indeed. There's no doubt that the Appeals Chamber was presented with a corrupted trial record. That's clear, and it's clear based on the findings of this chamber. The mere fact that the chamber found that the witnesses lied, even on matters going to the non-merits of the case, is in the trial record of the main case. And those are lies, intentional ones, elicited, solicited, and perpetrated by witnesses that were complicit with the plan and at the behest of the defense. The extent of that corruption is not known to this day, and it could not have been known to either the appeals chamber or any other chamber confronted with that record. The appeals chamber analysis was necessarily dependent on the corrupted trial record because appeals chamber analyses are dependent on the trial record. It had to be, and importantly, as the defendants intended it to be. We assert in our detailed notice, which I incorporate by reference as the chamber has also referred to this earlier this morning, that the appeals chamber tacitly accepted the false narratives of defense witnesses in its analysis of the trial chamber 3's assessment of evidence before it. Witnesses who this chamber determined beyond a reasonable doubt had been corruptly influenced. And it appears that there were others. At the end of the day, the result of the appeal achieved the very objective of the common criminal plan in which these defendants participated, which was Bemba's acquittal. And it would seem that anyone knowing the pervasive extent of the scheme to corruptly influence defense witnesses, nearly half of whom made up the charges on which the defendants were convicted in this case. Even the 14 out of 34 is quite a substantial number. Any reasonable person would and rightly should wonder whether there is a connection between the defendant's criminal conduct in corruptly influencing numerous defense witnesses to unlawfully achieve Mr. Bemba's acquittal, and that result having now come to pass. More than wonder, we say that there is. The fact that there is even a reasonable uncertainty, by the way, about whether the testimony in the record before the appeals chamber was that of a witness or that of Mr. Kilolo is evidence of the concrete damage done to the integrity of the court, its processes, its proceedings, and its credibility, the public confidence that should adhere to it. That there should be even a reservation or concern about a judgment issued by this court in the main case is but the direct product of the defendant's course of criminal conduct. The defendants polluted the trial record deliberately. It is a factor that this chamber cannot ignore, should not ignore, and rather must consider in the determination of the appropriate sentence under Rule 145. Still, and more precisely, the appeals chamber made three important findings which are at the heart of its decision to acquit Mr. Bemba, and we set them out in our notice. The first is that the trial chamber failed to pay sufficient attention to the fact that the MLC troops were operating in a foreign country with the attendant difficulties on Mr. Bemba's ability as a remote commander to take the necessary and reasonable measures. In fact, as your honors are probably aware, the narrative concerning the difficulties of Mr. Bemba purportedly as a remote commander is found in the corrupted evidence of D54, D15, D13, and D25, all of whom are very familiar to this chamber, and all of whom were proven beyond a reasonable doubt to have been corruptly influenced by the defendants. In the case of D54 and D15, you have before you the irrefutable proof in the form of intercepted communications wherein Mr. Kilolo is literally feeding them the very testimony that you now see reflected in the appeals chamber's assessment of the evidentiary analysis that was done by the trial chamber, an assessment which ultimately affected the outcome of the case. Second, the trial chamber failed to address Mr. Bemba's statement that he wrote to the Qatar Prime Minister requesting an international commission of inquiry to be set up, or the testimony of D48, which attested to the existence and content of this letter. As set out in our notice, D48, who was cited by the appeals chamber specifically, one of the few witnesses that is cited in relation to these findings. He was not a witness whose corrupt influencing was charged before this chamber. I believe that's what Ms. Taylor was alluding to. But you have before you the telephone records which show D48's numerous contacts with Mr. Kilolo in advance of his testimony in the main case on 6 November 2012. Those records were recognized as formally submitted before the Chamber on the 24th of September 2015. There are three of them. CAR OTP 0072-0081, CAR OTP 0072-0082, both disclosed on 13 December 2013, and CAR OTP-0072-0391, which was formally submitted, as I said, on the 24th of September 2015 and disclosed on the 31st of January 2014. In this case, those CDRs demonstrate that D48 withheld the fact of his multiple contacts and conversations with the defense prior to his testimony in the main case, which included a phone call which lasted for over an hour with Mr. Kilolo only days before he took the witness stand, and having been asked about his conversations with the defense, never divulged it. His tainting fell within the modus operandi of the common plan, as you found it, and determined beyond a reasonable doubt that the defendants in this case participated. His testimony was in the record before the appeals chamber. It's in the trial record, just like the other 14. But the records would show that he was not truthful about his conversations with the defense were not in the record. And not surprisingly, he was not truthful in exactly the same manner as nearly every witness that this chamber determined had been corruptly influenced by the defendants pursuant to the common plan. The appeals chamber could not have known about the CDRs. The appeals chamber could not have known about the truth or falsity of his response when asked about his conversations with the defense, and he failed to reveal those conversations. They couldn't have known because it wasn't part of the trial record. But you know that. The narrative that was provided by D48 was tacitly accepted by the appeals chamber, however, and it informed the decision to acquit. Third, that the trial chamber erred in attributing any limitations it found in the mandate, execution, and/or the results of the measures that Mr. Bemba undertook to him. This narrative is found in the tainted and corrupted evidence of D48 as well as D54. This chamber has before it evidence of their false testimony in the main case, and you have D48 now before you because you have the records, and his testimony is public. So you can see for yourself that the answer to the question that was put to him does not correspond to the evidence that you have in front of you. While the appeals chamber did not identify the source of the particular narrative which formed the basis of its criticism of the trial chamber's analysis, that the limitations in the mandate, execution, or results of the measures taken by Mr. Bemba were beyond him to begin with. What is clear is that the evidence provided by these tainted and corrupted witnesses on the Mondonga inquiry and the Zongo Commission resided in the trial record and remained there to be relied on by a chamber of this court, whether it be the trial chamber or the appeals chamber. It was there, and that's what it was there for. The acquittal obtained at the appellate level was, to a discernible extent, affected by the criminal conduct of Mr. Bemba, Kilolo, and Mengenda in the implementation of the scheme corruptly to influence defense witnesses, irreparably damaging the trial record on which the appeals chamber necessarily and foreseeably relied. There's no real question about that, and the chamber must consider it as a consequence of the defendant's conduct. The chamber has to take into consideration the consequences of the defendant's conduct.
Mr. Van der Poel, allow me at this moment, because I think it's exactly at this point that we should clarify something, and because of that I make this intervention now. Do we agree that the appeals chamber in the main case was aware of the fact that the findings of TC7 were final?
Yes,
Do we agree on that?
we agree on that.
Okay. So could you then please clarify for the chamber, does the OTP submit before this chamber that the appeals chamber majority in the main case relied on evidence that they knew was tainted when they acquitted Mr. Bemba?
That's a very good question and a difficult one to answer, because at the end of the day, we're not privy to what the appeals chamber relied on. What I do know, and what I can say, is that the entirety of the trial record was before the appeals chamber. And what I can say is that even if the appeals chamber had some inkling of which witnesses had been corruptly influenced, based on the finality of the trial chamber 7's judgment, and they used that as the measure to determine which witnesses were and which witnesses had not been tampered, then I can assure you they would have been wrong. Because even within the judgment of this trial chamber, findings were made which demonstrated the corrupt influence of witnesses that weren't charged before this, the incidents that weren't charged before this trial chamber. D7 is one, D9 is another, D19 is yet another. I can't recall all of the other witnesses that were referred to by D2 and D3, which this chamber credited. But we do know that the evidence that they provided before this chamber, and which this chamber credited, established that the witnesses that had been corrupted in the main case far exceeded the 14 that were charged. And that is the position that the prosecution has maintained in this case since day one. So it is entirely possible that if the appeals chamber relied on the finality of the convictions and the basis of the convictions in your judgment and in the appeals chamber's affirmation of that judgment, that they would have been wrong in the Bemba main case to discard or disregard 14 witnesses.
This is, of course, very hypothetical, frankly speaking, but nevertheless, I would appreciate it if you move to the next point. Perhaps I think enough has been said about that now.
Thank you, Mr. President. I just wanted to close it out, so to speak.
Yes, please shortly.
Just this section, by the way. What I wanted to say is, and I think it actually is responsive to the question that you just asked, is that we can't really underestimate the degree of corrosion in the record that was before the appeals chamber, and that the appeals chamber inevitably had to confront, and it was constrained to analyze the facts from. Mr. Bemba, at some point during these processes, withdrew his reliance on 14 witnesses. That was about a year or so after he'd been charged in this case. That didn't give a good indication of the witnesses that had been corrupted, because you know, through your own findings, that it wasn't limited to 14. It didn't preclude the consideration of the corrupt witnesses by any chamber. The record was never expunged with respect to the 14 witnesses or any other. The Bemba defense did not concede that witnesses corrupt influencing, nor did they withdraw their evidence from the record of the case. And as it turns out, we know, as you do, 14 were not the only ones. The prosecution has repeatedly stated this, as I've said, and the full extent of the defense witnesses corruptly influenced in this case, no one actually knows. They do. The defendants know, but we don't know, and no chamber of this court knows. That is the harm, that is the danger, and that's one of the consequences of their conduct. I'd like to come to some of the errors that were identified by the appeals chamber in respect of this trial chamber's judgment, if I may. I see you may have some questions, though.
No. I appreciated that you, you moved to these points.
Okay.
Now.
I confused the expression for. All right. The first is that the chamber, the appeals chamber found an error with respect to this trial chamber's assessment of the gravity of the crimes. And I won't belabor the points that are made in our previous submissions. What they determined was that there was an error in the chamber's assessment of false testimony, which did not go to the merits of the case, as somehow inherently less grave than false testimony, which does. But I think it still bears repeating that no such generalized distinction can be drawn under the statutory framework. And to the extent that the chamber determined that witnesses testified falsely in the main case, the gravity of the defendant's conduct cannot be diminished on a finding that the false testimony goes to non-merits of the case, especially absent a fact-specific determination or assessment by the chamber. However, in this case, the very purpose of the false evidence that was proffered by the corruptly influenced witnesses was clearly to ensure that the lies that they told and the illicit coaching that they received in respect of the substantive matters that they testified to in the case would go undetected. They would go undetected by the chamber, and they would reside in the trial record as such to be relied on. The very purpose of the witnesses lying about their contacts with the defense, their conversations, their meetings, their calls, the monies and other things of value that they received, the bribes that they received, the inducements that they received and were presented to them. The whole purpose of it was so that their credibility could not be assailed, their evidence could not be fairly assessed regarding the substantive evidence that they provided. The purpose of the non-merits lies was to ensure that those lies which went to the substantive issues in the main case could be more effectively delivered and influence a chamber. It was so that the chamber would believe the witness. It was so that the testimony would appear spontaneous. It was so that it would be credited by the chamber. It was so that the objectives of the common plan could be achieved without discovery. To diminish the gravity of the defendant's conduct on this basis is not only untenable, but if anything, in the circumstances of this case, it's even worse. The lies told on the non-merits of the main case concealed the corrupt influence of the witnesses on whom Trial Chamber 3 was made to depend, on whom the appeals chamber was made to depend. It allowed the insidious plan to corrupt witnesses to survive and thrive, and it made it virtually undetectable. The corruption of witnesses who testified in Bemba's favor on core matters concerning his responsibility, that is, to his effective control, the work of the commissions of inquiry, the nature and extent of investigations ostensibly conducted regarding the MLC crimes, his knowledge of those crimes committed by MLC forces. That's what it was about. Don't forget the example of D15's intercepted communications, wherein Mr. Kilolo tells him explicitly that his testimony needs to diminish Mr. Bemba's knowledge. He says, donc c'était pour réduire l'élément de connaissance. Ça, c'était ma première préoccupation. That's what he's telling the witness who's about to get on the witness stand and testify to exactly that. To advance arguments to show that it was impossible for Mr. Bemba to exercise command and control over MLC forces operating in the car. That sounds familiar. And he's telling the witness in this intercepted conversation that there are many arguments which show that it was impossible. That's what he's telling the witness. That there was no evidence of MLC forces' commission of crimes. Il n'y avait aucune information précise. C'était des simples rumeurs. That's what he's telling the witness. All of these facts, if all of these facts were true, why in the world would he go to these lengths? Why in the world would they go and coach 14 witnesses that you found that had done? And it's not just D15, but it's every other witness that you considered. The non-merits lies do not give rise to any mitigating consideration in terms of the gravity of the conduct, because rather they demonstrate the depth and the degree of planning, design, preparation, and calculation that was done by the defendants to best ensure the success of their common criminal plan. Preparing a witness on how to best avoid detection and giving evidence before a chamber in a serious case on where they've been illicitly coached on matters that go to the merits of that case by withholding and or lying about information which, if known to the chamber, and that's important, if it was known to the chamber, it would justify its utter rejection of that evidence and would inevitably reveal the criminal plan. That cannot possibly entitle a defendant to some weight in mitigation of sentence. The analysis is exactly the opposite. It warrants an even greater sanction because it evidences the deliberateness of the criminal plan, evermore, and the surreptitious manner in which it was carried out. In Kilolo and Mengenda's case, they're both lawyers, Your Honors. They knew exactly what they were doing and what it was about. The second error, again, I won't belabor the points that we've made in our previous submissions on the appeals chamber's determination of error regarding the trial chamber having distinguished between principal and accessorial modes of liability in terms of their impact on its sentencing determinations. Specifically, that accessorial modes of liability are effectively less serious than those which arise under the liability form as a principal. The error in this case principally affects the chamber's determination of the appropriate sentences for Mr. Bemba and Mr. Kilolo for their Article 71A convictions pursuant to 25(3)B, soliciting and inducing. But obviously, the principle that was pronounced by the appeals chamber affects all of the chamber's sentencing determinations, which are predicated on this erroneous distinction, including the sentence it imposed under Article 25(3)C concerning Mr. Mengenda's convictions for violations for Article 71A. The fact that as a matter of law there's no automatic differential impact on the determination of sentence which arises from whether a mode of liability is as a principal or as an accessory means that the mitigation that was applied by the chamber dissolves, and the imposition of a higher sentence is warranted absent any fact-specific determination of all of the variable circumstances on a case-by-case basis and correspondingly reasoned basis for any such distinction. Here is the case, as is the case concerning the 71B offenses, which I'll come to also. The chamber's assessment of the relevant facts, gravity, and the underlying conduct for the offenses for all three Article 70 offenses that it found were essentially the same. The degree of the defendant's culpability should not therefore be diminished in terms of the Chamber's assessment of sentence on the basis of the mode of liability. Indeed, insofar as the assessment of the gravity of the defendant's culpable conduct concerns both the acts comprising the crimes themselves and those comprising the modes of liability, there is no basis in this case for mitigating the determination of sentence in respect of the accessorial modes of liability found for any given crime. The three defendants before you are the principal participants in a common criminal plan which involved the systematic and pervasive corruption of defense witnesses in a trial of crimes of the most serious concern to the international community. This is no small affair. It was a case, as you know, with 5,000 victims, participants, more, I think. The Chamber should not be in the business of splitting hairs in these circumstances. Not only were they culpable participants in the common plan and essentially contributed to it, it revolved around them, these three, and their fundamental culpability and responsibility for the crimes committed pursuant to that common plan and related to that common plan were found in this case is crystal clear. That culpability requires not less than the 5 years that we have requested. We'll talk about the impact of the Appeals Chamber's reversal of the convictions entered under Article 71B for the defendants. The Appeals Chamber's dismissal of the convictions imposed under Article 71B do not militate against the imposition of the maximum sentence for the crimes under Article 71A and Article 71C. The gravity of the numerous crimes for which the defendants were convicted is not changed at all by the dismissal of their convictions under Article 71B. Simply put, because the underlying conduct which goes to the gravity of Article 71B crimes, of which all three were convicted, because that is captured in the conduct of the very same, or rather in the crimes, based on the very same conduct under Article 71C. The fact that they could not be convicted of presenting those witnesses because the Appeals Chamber found that presenting evidence related to documentary evidence. That fact does not at all mitigate the sentence or their culpability under the remaining charges, rather. Fundamentally, that is what the case is about and always was about, is their fundamental and incessant determination to undermine the proceedings before this court. However one wishes to legally characterize their conduct, the fact is that in the circumstances of this case, their individual culpability for the crimes perpetrated pursuant to the common plan is immutable. It doesn't matter what they're convicted of at the end of the day under Article 70. A simple act of bribing a witness can comprise both the solicitation or inducement of false testimony and as a means of persuading the witness, for example, and at the same time comprise their corrupt influencing. It's the same thing. It's a difference, or a distinction rather, without a difference. The Chamber itself recognized this type of overlap in its findings, and that's at paragraphs 894 through 933 of the judgment. And the Appeals Chamber similarly recognized it in this case. The bottom line is this, Your Honors, that no matter how you turn this case around, no matter what angle it's looked at from, and no matter how the defendant's conduct is characterized or recharacterized and characterized again, the gravity of the crimes and the defendant's conduct do not depend on their legal characterization. The gravity assessment for which a sentence is determined and imposed adheres to the totality of the criminal conduct of the defendant. Make no mistake, the defendants before you corruptly influenced the 14 witnesses which were the subject of the charges in this case. You found that to be so beyond a reasonable doubt. And that, as I said, was nearly half of all of the defense witnesses presented in the main case. And like I said, and as you know, there were more. That's not just proved in this case. It's just a matter of common sense. They participated in and contributed to a common plan that was designed to achieve Mr. Bemba's acquittal through criminal means, and they did it. The determination of the appropriate sentence cannot change on the basis that they were erroneously convicted of a crime that they were otherwise properly convicted of on the same basis under a different characterization. Again, a contrary conclusion would be completely untenable. In respect of the defense submissions on sentence, in a nutshell, Mr. Kilolo's request is that the chamber refashion his sentence along similar lines to Mr. Mangenda's request. Mr. Mangenda requested a delayed sentence. Functionally, this is pretty much the same as what was turned around by the appeals chamber to begin with, because it violates the appeals chamber's determination that a chamber is bound to apply the statutory framework, cannot depart from it. And the statutory framework does not provide for the requested sentences. The chamber, this chamber, is constrained to sentence a convicted person as provided for under the statute only. And in this case, a term of imprisonment, a fine, or both is what is provided. So it's not an option. It's not an option not only because it would be ultra vires, but because it would not even approximate the scope of their culpability for the consequences of their conduct. The culpability and conduct, I might add, that none of these defendants has ever expressed any genuine remorse for. None of these defendants has ever apologized for their conduct, let alone acknowledged it. None has apologized to the victims who were before this court of last resort to seek justice, the justice that they intentionally interfered with. None of them has issued a statement. None of them has provided information to the court so that we don't actually have to debate the question of which witnesses were relied on and which witnesses were corrupted in the record of the main case. We don't know that because nobody will tell us that. They haven't told us that. They haven't apologized for their conduct. They haven't acknowledged it. None of that is before the chamber. In the video, or rather the statement that I referred to that Mr. Kilolo made, I believe it was on the 11th of June, I referred to it earlier. During his interview, he said the prosecutor should resign. That, I would submit, does not show someone who has acknowledged the conduct of which he has been convicted by this chamber. It doesn't show a shred of remorse for the behavior, criminal behavior I might add, that has been found beyond a reasonable doubt, not just by this trial chamber, but also by the appeals chamber. This court should take that into consideration as well in determining what the appropriate sentence is. You're going to hear from the defense, I'm certain, regarding their individual circumstances, their personal circumstances, home, family, the hardships that they've felt with, the accomplishments that they've made, their contributions to the community, all to encourage the court to mitigate the sentences that they should receive in this case. And I'm not going to get into that. But what I will ask you to do is that when you consider and you listen to the arguments concerning them, that you weigh them against the circumstances of the victims of the crimes, which everyone knows were the subject of the main case. There are victims of the crimes in that case. No question about that. They were before this court as a court of last resort to seek justice. They didn't get it. The crimes that they were victims of were atrocities. They were victims of crimes committed by the MLC. The justice that they were entitled to, and that this court, should have been able to provide them, was compromised by the acts of these defendants. When you've done that, I would ask that you ask yourself, what are the circumstances that the victims find themselves in now? And ask yourself, what is this case worth at the end of the day? Your Honors, when this chamber rendered its judgment of conviction in October 2016, it said importantly, quote, "It has become apparent in the short time span of the court's existence that preventing offenses against the administration of justice is of the utmost importance to the functioning of the International Criminal Court. Such offenses have this significance because criminal interference with witnesses may impede the discovery of the truth in cases involving genocide, crimes against humanity, and war crimes. They have this significance because they may impede justice to victims of the most atrocious crimes. And ultimately, they may impede the court's ability to fulfill its mandate." The words were powerful and they resonated. But at the end of the day, they're just words. Their utterance alone doesn't give them meaning. That comes with what the chamber, the court, the institution actually does about these crimes. The sentence that this chamber imposes will determine what meaning those very powerful and resonant words and wise words will have, if any. For now, that rests with the chamber. As I said, the appeals chamber's remand of this case for a new sentencing determination is a reprieve. And it's really an opportunity for this chamber to do what is necessary and to do what is right. And that is to impose the maximum sentence of 5 years and a substantial fine for all 3 of the defendants. And we acknowledge that that's a heavy burden. And it's a responsibility that, believe me, I don't envy. But it's beyond doubt the right decision in this case, in these circumstances. That concludes my submissions, Mr. President. If you have any questions regarding them, I'll be more than happy to attend to that.
No, thank you very much. I don't have any questions at the moment. Then we could start with the defense teams. In which sequence? Have you already conferred with each other? And it depends a little bit also on the time that you would need. So I would say if one of the defense teams would be able to finish in 45 minutes.
I could, Your Honor. I can go first.
Then if the other two, Mr. Gosnell and Ms. Taylor, they would not object, I think, to you going first. Yeah. Thank you. You have the floor then, Mr. Canos.
Good morning again, Mr. President and Your Honors. On my first appearance in federal court in the United States, I had an old judge tell me, "I don't know if your client is paying you for 1 hour, 3 hours, 5 hours. I'm only going to listen to the first 15 minutes. So tell me what I need to hear in 15 minutes, and then keep talking so you can build your client. So I will speak for 15 minutes or so.
Oh, I would have even been more generous, but please go forward.
You already sat through the trial. You heard all the evidence. And I have to believe that having read the judgment, the sentencing decision, that you carefully considered all of the facts. So nothing that you've heard today is news. I will address the issue of the acquittal at the end, but I want to focus on why we are here today. Now, I've looked at the appeal judgment. I studied it, and I tried to figure out what was it exactly that caused them to remand this case back, remand it to you folks to resentence. And it seems to me that there might have been some misapprehension on the part of the appeals chamber on two matters. Perhaps because it wasn't quite clear in the sentencing decision that you may not have provided sufficient reasoning. And they jumped to the conclusion, if I could say that, with all due respect to the appeals chamber, that you found as a matter of law that on the two errors, one dealing with gravity and one dealing with culpability, that there is some sort of a hierarchy. And they assumed, I think that was the word that they used, that they assumed that you applied this principle without doing an individualized factual analysis, which in my opinion, granted I'm not a judge, so I wouldn't presume to know how they think, but it seems to me from reading the sentencing decision that you actually went through the analysis. Be that as it may, we're very grateful to the appeals chamber for clarifying this legal issue. And it seems to me what they're inviting you to do is to provide further reasoning as to how is it that you reached the result that you reached. That's my interpretation. That's all I'm going to say on those two issues. As far as the reversal of the 14 counts, the prosecution would have you believe that, well, it doesn't really matter because it's basically the same conduct, so what? However, when I read your sentencing decision, it's very clear that you considered it. And having considered it, obviously, you must have given it some weight. Now, the fact that those 14 counts are no longer with you, it does merit some reduction, or at least a consideration. As far as the one factual error that was found, and it was found to be harmless, and that was the time frame, you'd indicated that it was approximately close to 2 years versus they found 13 months where the period where the offenses were occurred. The prosecution correctly says, well, doesn't really make a difference because in that instance, both the trial chamber and the appeal chamber effectively indicated that it was a long period. It was a substantial period. And I can understand that. But that goes, Your Honor, that's a harmless error concerning not sentencing, but concerning something else. For sentencing purposes, you took into consideration, you consider this as a factor in determining the sentence, the period. Turns out that the period is much less. So while it is lengthy is an abstract notion. It's like asking how long is a string. It all depends. But when you and I suggest that you didn't consider the abstract notion of lengthy, you considered the concrete fact of close to 24 months versus 13 months. And therefore, now that you have a reduction in time, it seems that it warrants at least consideration in a reduction in whatever sentence you intend to impose. Now I want to talk about the ultra vires. And here's where I really want to focus my attention to, because I think this is and I think the appeals chamber, by the way, got it wrong. With all due respect, I think that it is within a trial judge's inherent judicial authority, especially when it comes to sentencing. They had wide discretion. But be that as it may, it's ultra vires. But let me focus my attention to you on what it is that you found and why we maintain the 11 months is the period of actual incarceration that should be imposed here today, irrespective of the errors that the appeals chamber found. When you fashioned the decision, when you were deliberating, and I wasn't there, but I assume that in your mind, as judges, you already had considered the fact that you had the discretionary authority to suspend part of the sentence. It's quite clear that you broke it down. 12 months here, 24 months there, you shorten it to 30 months. Then you decided, okay, based on this, based on the fact that we have this inherent authority, how much time do we actually want this individual, Mr. Kilolo, to be in prison? And the answer was 11 months. There was never, ever, ever any intention on your part for him to serve the other 19 months. How do I know that? Because no judge, at least none that I'm aware of, actually wants to see an accused person who has a suspended sentence be back to serve it either, on a part-time basis or all at once. The purpose for putting in a suspended part of the sentence is twofold. One, get your act together. Stay clean. Get a job. Stay out of trouble. The other one is protection for society. Because we want, during this period, we want a sort of Damocles hanging over this person's head to make sure that he doesn't reoffend or she doesn't reoffend. So I have to believe that when you figured out that it was 30 months, the 19th to be suspended, what you had in mind was the actual period of incarceration should only be 11 months and no more. And therefore, and I'm happy to hear that the prosecution is at least not inviting you, teasing you, to go with 30 months, because obviously you at least found that 30 months was warranted as a sentence. That 30-month period was with the understanding that you had the inherent power to suspend 19 months, of which you never intended Mr. Kilolo to serve. Why? Because you had already determined by the time that the judgment was rendered that he already re-entered society, that he was abiding by all of the conditions. And dare I say that by placing a period of probation over his head, for all intents and purposes, even though we now know it's ultra vires, he was effectively under probation. And he was at least abiding by all of the conditions of the probation. And I think at the very minimum, if it's not a mitigating factor, that is the additional time that he has spent without reoffending, trying to get back on his feet, I think that has to be considered. That has to be considered, because what is the sense? What is the sense of putting somebody, warehousing somebody back in prison for the amount of time that the prosecution is asking you? They're asking you for an additional 49 months. What will that do to an individual such as Mr. Kilolo? Bankrupt him? Who knows what his family situation will be? How will he be able to get back on his feet? And how does it justify? Where does he pick up his life from there? But aside from that, the prosecution tells us be unsentimental. And judges have to be unsentimental to a certain extent. You have to be dispassionate. I understand that. And my heart goes out to the victims. Trust me, and I'm going to get to that. However, could you have been so wrong to have gotten between 11 months and an additional 49 months? I cannot believe that. Not when I look at the very attentive nature to all of the facts that you paid in both what I would consider one of the best judgments I've ever read as far as factual analysis. I'm not just saying this, I've said this privately, but also in your sentencing decision. You were very, very concrete in how you went through about making that determination. How could you have been so wrong that you were off by 49 months? Now let's talk about the victims, and let's talk a little bit about this acquittal of Mr. Bemba. I don't know Mr. Bemba. I never met Mr. Bemba. I know the team a little bit, but I've never spoken to them about the case. I have read the appeal. I've read it rather thoroughly, in fact. And here's what my impression is. The prosecution failed, and they failed miserably. They didn't properly investigate the case. They didn't properly charge the case. They went to the prom with one date, and then they wanted to come out with another. They charge in one way, in a sense, and then at the end of the trial, they want to argue it in another way. And, of course, on appeal, you have 3 judges who are highly experienced, who are not biased, one of whom, as I understand it, I could be wrong, but I think one of them also was on the appeals chamber that rendered for this particular case. They looked at all of the evidence. Now they say, as Madam Bensouda was quick to go out and publicly proclaim that there was a misapplication of the standard of review. That's baloney. That's not how I read it. I read it very carefully. They applied the standard. What they did was they did their judicial duty and go beyond the mere surface when they thought that the trial chamber had ignored relevant defense evidence, particularly when related to circumstantial evidence, when inferences were being drawn. And they had a judicial duty to look into it. Now the prosecution says all of that was false. Now is not the time to litigate that case. Now is not the time to litigate that case. They had their chance. And once, as I understand, because I wasn't around that period, but as I understand, at some point during that trial, the prosecution understood and knew and was monitoring the situation. It was at that point in time that they could have said something. But the way I look at it, and the way I've understood the appeal judgment, having read it, the evidence, much of the evidence that was relied on comes through cross-examination. And so now it's more than just sour grapes. Now the prosecution wants to whitewash and wants to scapegoat by now claiming that those 5,000 victims did not get their day in court because of these individuals over here, rather than accept responsibility. And I think, Your Honors, I understand if I was the prosecutor, I'd probably do the same. I would probably submit to my devilish side and say, okay, why not go for this? But I think this is not the time. I think you need to stand fast. We're here for this case. Very specific purpose. It was remanded with a very narrow purpose. This is not the time to relitigate. And while I appreciate the eloquence of my colleague, I submit that the only reasonable sentence of incarceration in total would be 11 months, the time that Mr. Kilolo served, and allow the fine to stand as is. Thank you very much.
Thank you very much. That was indeed short and sharp, let me put it this way. So the question would be, I would like to inquire first with Ms. Taylor and then with Mr. Gosnell. Do you have already an idea how long it will take you? And then we decide when we have a break and how long we will have a break.
Thank you, Mr. President. I believe that my submissions will be approximately an hour and 15 minutes, but I'm happy to commence before the break. Thank you.
Okay. Mr. Gosnell?
Mr. President, I believe I could conclude my submissions in under 25 minutes.
Yeah, then I would simply suggest, if you don't object to that, Ms. Taylor, that Mr. Gosnell has now the floor, and then after the intervention of Mr. Gosnell, we will have the break.
Mr. President, I would request to proceed on the order in the indictment, namely third. And the reason for that, Mr. President, is not to cause scheduling problems, but simply I believe that Ms. Taylor's submissions may be covering some of the matters that I would or would not address depending on how she addresses them.
No, that is conceded. Then we start with Ms. Taylor and perhaps half an hour, and you can tell us at a point of your submissions when you think we can have a break. So please, you have the floor.
Thank you very much, Mr. President. We are here today because the Appeals Chamber ordered the trial chamber to determine a new sentence in light of several errors, including, and importantly, an error that led to a third of the charges against Mr. Bemba being dismissed. But from our perspective, and most importantly, we're here today because after these proceedings commenced, the Appeals Chamber issued a judgment acquitting Mr. Bemba of all charges in the main case. As we've discussed, this acquittal is final, and it has clear consequences for the sentence that the Chamber must now impose in this case. In particular, as concerns the type of punishment that should be imposed on someone who has already served twice the maximum length of detention for an offence of this kind. Now, in our respectful view, none of the errors identified by the Appeals Chamber justify an increase in punishment, particularly when they are set off against his acquittal under Article 71B. But the fact that Mr. Bemba's unspent detention has gone from 0 days to 10 years overnight justifies a significant rethink and readjustment of the sentence and punishment that should be imposed at this juncture. Now, at first glance, it might appear that the best solution would be to declare a sentence that's approximate to some kind of time served and drop the fine. For example, if the ICTY Hartman yardstick is used, that is 1,000 euros equals 1 day in detention, it's clear that the additional time in custody that he has served under the Article 70 warrant alone equates to a fine of 1.6 million euros already. But this sentence, this type of easy solution, would be fundamentally unfair. It would be an outcome determined by extraneous circumstances rather than the degree of his culpability. It would not be a just outcome for either Mr. Bemba or the victims in the main case. Rather, the amount of time that he's actually served in jail has meant that the scales of justice have tipped, and they've tipped towards the objectives of rehabilitation rather than vengeance. As a result, the Chamber now has a duty to craft an outcome that doesn't entail any additional punishment beyond restorative justice. An outcome that would allow Mr. Bemba, his family, and the victims in the main case to rebuild their lives and those of others. In our respectful view, that outcome will be to order Mr. Bemba to pay a reasonable fine to the Trust Fund for Victims, which can be allocated to the victims in the main case, and to discharge the case against him. Now, in terms of the structure of my submissions, I will address firstly the degree of his participation under Article 71A. Secondly, the degree of harm caused by the specific false testimony underpinning the conviction. Thirdly, the impact of his acquittal on the length of his detention in the Article 70 case, that is under the Article 70 arrest warrant. And fourthly, the appropriate sentence that should now be imposed in light of these factors, in particular the length of his detention. And I believe I should be able to finish the first topic before the break. Now, in terms of this error, this issue of the degree of participation, we submit that it's correct that it is necessary to impose a lesser punishment in connection with Mr. Bemba's conviction under solicitation. Now, this distinction between co-perpetration and solicitation and the type of punishment that was imposed on him necessarily follows from the type of offence that we're dealing with here and the specific degree of his participation in that offence. Now, this aspect was canvassed in our written submissions, and this first issue refers to the fact that false testimony is, by its nature, it's driven by the witness. It is the witness who takes the oath. It is the witness who has control over the answers that they give. And it is the witness who bears the primary responsibility for any lies that they've told to the court. And this witness-centric nature of Article 71A stands in contrast to corruption, where the focus falls on the conduct of the person who is driving the corruption. And that justifies the difference in approach adopted by this chamber. And this difference in approach is also consistent with the degree of his participation. Now, the prosecution has complained that the chamber's finding in this regard might lack elaboration. But perhaps that lack of elaboration stems in turn from the chamber's approach to the admissibility of evidence in this case, and that the findings in that section refer to the evidence or the whole evidence. So that's a symptom of the legal approach and not the validity of the chamber's findings. In any case, the restricted nature of his participation is consistent with the fact that he was convicted for solicitation and not for inducement and not for co-perpetration. In the Labunga case, the appeals chamber found, at paragraph 468, on the judgment on the merits, that the blameworthiness of the person is directly dependent on the extent to which the person actually contributed to the crime in question. This means that this sentence can only take into consideration the actual contribution underpinning the conviction itself. A person who has been charged, a person who has been convicted for solicitation, can't be sentenced as a co-perpetrator. You simply can't use a lower threshold to secure their conviction and then rely upon a higher threshold for the purposes of sentencing. Now, if a higher threshold was going to apply to his degree of participation, we should have had the benefit of that at trial. We should have been able to defend ourselves in relation to that against the conviction, and not now at the very end of the road. And the contributions of a person who solicits an offence are less than the person who, as a co-perpetrator, makes an essential contribution to that offence. And if I may have the floor to show a document.
The defense has the floor.
I believe it should come up on your screen, a graph which shows the gradations of participation between And in this graph, you can see there is a difference. There's a difference in the degree of contribution. And if we use the Lubanga Appeals Chamber approach, this difference reflects a difference in culpability and necessarily a difference in the distinction in punishment. And the prosecution has failed to prove to the contrary, and a different approach should now be adopted. And is that a good time to finish, or should I continue?
If you want to finish here, I think it's a good time. You could also continue, but I would not want you to interrupt one of your points that you already said you would elaborate upon.
I think now would be an appropriate time.
Then we.
I just have a question.
Yeah, please.
I see the graph in front of me, Miss Taylor, and where did you get this from? I'm sorry. Please.
It's from an article which is in our table of authorities under this particular section. I believe it's by Melissa Conway. It's Ordering Individual Criminal Responsibility. It's an article that only recently came out. We were only able to obtain it last week. That's why it wasn't included in our submissions.
Thank you, Mr. Chairman.
And why not continue on that a little bit when we look at this graph? And I'm interested in the middle part, substantial. How do you read this from the bottom to the top, or from the top to the bottom?
Well, one can see that co-perpetration theory, which is what Mr. Bemba was convicted for under Article 71C, requires an essential contribution. And that mirrors the Chamber's findings in this case. Whereas you then have, the Chamber, I understand, referred to solicitation, which must have an impact on the crime. And it found that solicitation itself was almost a lesser form of inducement. So it creates here a level of contribution, not a level of hierarchy, but a hierarchy which is based on contribution, which is exactly what the Lubanga Appeals judgment said that the court should do. Not look at whether it's Article 25(3)A or B or C, but look at the level of contribution that was required for that specific liability.
And is, in your opinion, in this substantial middle part, a gradation between the different modes of participation? For example, between ordering and soliciting and aiding and abetting? Or
Well,
is there a hierarchy, or can there be a hierarchy? It's just in your opinion, I'm interested.
Well, I think this graph is looking at the specific elements of the modes of liability. For example, when one looks at co-perpetration, it's necessary to make an essential contribution to the outcome, and you also have to have the mens rea, you intend it to occur. Now, for ordering, inducing, and soliciting, this article posits that the degree of mens rea might be similar, but the actual contribution to the outcome of the crime differs, and it differs depending on the type of liability that one is using. And that is fully reflective of the Chamber's approach in this case, which referred to co-perpetration requiring an essential contribution, and it made a distinction between inducement and between solicitation. And it's also consistent with what the Appeals Chamber specifically says about false testimony. That is, when a witness is on the stand, the witness controls the answer they're giving. They control it, not the parties. The parties might impact upon it, but it is an impact. It's not exclusive or essential control.
Thank you very much. We will then have the lunch break until 2 o'clock.
Thank you.
All rise. Voy a volver.